that the president, in taking some activity against the individual, has exceeded Congress's authorizations or his powers. The best I can do in answering your question, because there are so many pending cases addressing this issue in such a different variety of ways, is to say that the best expression of how to address this always in a particular situation was made by Justice Jackson in his concurrence in the Youngstown steel seizure cases. And that involved President Truman's seizure of steel factories. There, Justice Jackson has sort of set off the framework in articulation that no one's thought of a better way to make it. He says that you always have to look at an assertion by the president that he or she is acting within executive power in the context of what Congress has done or not done. And he always starts with, first you look at whether Congress has expressly or implicitly addressed or authorized the president to act in a certain way, and if the president has, then he's acting at his highest stature of power. If the president is acting in prohibition of an express or implied act of Congress, then he's working at his lowest ebbs. If he's acting where Congress hasn't spoken, then we're in what Justice Jackson called the zone of twilight. The issue in any particular case is always starting with what Congress says or has not said, and then looking at what the Constitution says about the powers of the president, minus Congress's powers in that area. You can't speak more specifically than that in response to your statement that were part of your question, other than to say the president can't act in violation of the Constitution. No one's above the law. But what that is in a particular situation has to be looked at in the factual scenario before the court.